Welcome to SQE 1 Preparation Criminal Practice, the role of the defence solicitor at the police station by Street Lawyer, helping you to pass first time. FLK2 Criminal Law and Practice Specification says this: procedure for interviewing a suspect under PACE 1984, role and appropriate conduct by defence legal representatives, solicitor, including representation of vulnerable client, role of the appropriate adult, and who can be an appropriate adult. Separate classes are on solicitor conduct issues at the police station and advising the client on the right to silence and adverse inferences. So the question is here is, what key knowledge is covered in this class? Well, there's a focus on the role of the defence solicitor, DS, at the police station representing their client. And I'm going to be focusing on areas of consultation with the custody officer, police disclosure with the interviewing officer, private consultation with the client, and the police interview, what the defence solicitor can and cannot do, when the defence solicitor can and cannot intervene in a police interview, and when the defence solicitor can and cannot be removed from the police interview, and who can do the removing. By way of exam tip, pay careful attention to whether an interviewing officer is required to provide disclosure to the defence solicitor, what would amount to unacceptable behaviour by the defence solicitor and interviewing officer, when the defence solicitor can be removed from a police interview, who the interviewing officer has to consult, and the rank of the officer who makes the final decision. Now, there's a series of test your knowledge questions, 1 to 4. So the first one is test your knowledge 1. Is the defence solicitor entitled to a copy of their juvenile's client's custody record at the police station? A, no, because their client has not yet been charged with an offence. B, yes, because the defence solicitor is entitled to a copy of the custody record on arrival at the police station. C, no, because at this stage you are only entitled to inspect the custody record. D, yes, because suspect is a juvenile suspect, you have a right to a copy of it at this stage of the investigation. And E, because only the client's appropriate adult can request a copy of the custody record. Test your knowledge 2. Which of the following best describes whether the investigating officer is required to provide disclosure to the defence solicitor before the suspect's interview? A, there is no legal obligation to provide disclosure pre-charge. B, this is entirely at the investigating officer's discretion, but some disclosure will usually be provided to prevent the suspect from exercising his right to silence. C, the requirement only applies where a suspect is legally represented and the legal representative is able to persuade the investigating officer to provide disclosure. D, the requirement only applies where the suspect is a juvenile and their appropriate adult requires disclosure. Or is it E, the requirement is to give you sufficient information to enable you to understand the nature of any such offence and why the suspect is suspected of committing it. Test your knowledge 3. Is this: the interviewing police officer can dictate where the defence solicitor should sit in the police interview room. Is this statement true or false? And test your knowledge 4. Under what circumstances can a defence solicitor be removed from the interview room? Is it A, the defence solicitor can only be removed on the authority of an officer not below the rank of superintendent if the interviewing officer considers that the conduct of the defence solicitor is preventing them from properly putting questions to the suspect. B, the defence solicitor can only be removed on the authority of the custody officer who will hear representations from interviewing officer and the defence solicitor, as well as listening to the recording of the orderly recorded interview before the custody officer makes their decision. Or is the answer C, the defence solicitor has not prevented the interviewing officer from continuing to question the suspect and they cannot be removed other than on the authority of an officer not below the rank of inspector, not involved in the investigation of the offence. Question: what is the role of the defence solicitor at the police station? Well, this is in the Code C of the Police Codes of Practice. The solicitor's only role in the police station is to protect and advance the legal rights of their client. On occasions, this may require the solicitor to give advice which has the effect of the client avoiding giving evidence which strengthens the prosecution case. Question: can you provide an overview of the work of a defence solicitor at the police station? Well, let's split this up into 3 parts. Before the police interview, consultation with the custody officer, including inspecting the custody record, obtaining police disclosure from the interviewing officers, And then there's a private consultation with their client, all taking place before the police interview. Then during the police interview, the role of the defence solicitor is to advise their client during the police interview, intervene to challenge any improper police questions and conduct. And after the police interview is to make representations on the outcome and police bail. Question: what does the defence solicitor do when they meet the custody officer? Well, at the police station, the defence solicitor may consult directly with the custody officer and will inspect the custody record. Code C says this, and it's very important. The detainee solicitor and appropriate adult must be permitted to inspect the whole of the detainee's custody record as soon as practicable after their arrival at the station and at any other time on request whilst the person is detained. This includes the following specific records relating to the reason for the detainee's arrest and detention and the offence concerned, to which paragraph 3.1b refers. A, the information about the circumstances and reasons for the detainee's arrest as recorded in the custody record in accordance with paragraph 4.3 Code G. This applies to any further offences for which the detainee is arrested whilst in custody. And B, the record of the grounds of each authorization to keep the person in custody. Trying to break this one down. So what is the custody record? This is a record of all the significant events related to the suspect at the police station. The defence solicitor therefore checks and confirms the following: the name, address, date of birth of the client, offence for which their client was arrested for, the time of arrest, time of arrival at the police station, time the custody officer authorizes detention. All of these points are relevant relating to the detention and review clocks mentioned in another class. Any significant comments by their client to the police, suspect's medical condition and treatment, results of any searches, and any interviews that have already taken place. Question: when can a defence solicitor obtain a copy of the custody record? Very important. After the police station. Code C, paragraph 2.4, when a detainee leaves police detention or is taken before a court, they, their legal representative or appropriate adult, shall be given on request a copy of the custody record as soon as practicable. This entitlement lasts for 12 months after release. In practice, during the defence solicitor's attendance, some custody officers may provide a copy of the front sheet of the custody record which contains basic details. But remember this: the defence solicitor is entitled to a copy after the police station attendance as set out in paragraph 2.4a, but not at the police station, where they are only entitled to inspect the custody record. Question: what does the defence solicitor do when they meet the interviewing officer? This is commonly known as the police disclosure stage. The interviewing police officer may disclose to the defence solicitor circumstances of the arrest and the offence, the evidence, witness statements, CCTV, fingerprint documents, search results, further police investigations, whether the defence have enough evidence to charge, previous convictions, if any, of their client. In practice, in most circumstances, the defence solicitor obtains as much disclosure from the interviewing officer so they can properly advise their client on the strengths and weaknesses of the case against them and to advise their client accordingly. In practice, there's varying degrees of police disclosure, from officers who may show all the written statements they've obtained so far to only brief oral summaries of the allegations against their client. Question: is a police officer obliged to provide police disclosure? This is contained in Code C, paragraph 11.18. Very, very important to know this. An interview is the questioning of a person regarding their involvement or suspected involvement in a criminal offence or offences which under paragraph 10.1 must be carried out under caution. Now, before a person is interviewed, they, and if they are represented, their solicitor must be given sufficient information to enable them to understand the nature of any such offence and why they are suspected of committing it, in order to allow for the effective exercise of the rights of the defence. However, whilst the information must always be sufficient for the person to understand the nature of any offence, this does not require the disclosure of details at a time which might prejudice the criminal investigation. The decision about what needs to be disclosed for the purposes of this requirement therefore rests with the investigating officer, who has sufficient knowledge of the case to make that decision. The officer who discloses the information shall make a record of the information disclosed and when it was disclosed. This record may be made in the interview record, in the officer's report book or other form provided for this purpose. Question, private consultation. What does the defence solicitor do when they meet their client? Basically, there are 4 phases to the private consultation, which takes place in a private room. 1, defence solicitor explains their identity, role and funding, the details of the alleged offence, what the police have disclosed, any further police investigation. 2, take their client's instructions, and 3, advises the client on defences, strengths and weaknesses of the police case and whether to answer police questions or not. And then there's a 4th stage, which is to prepare the client for the police interview. Question, how does the defence solicitor prepare a client for police interview? Well, they provide advice, advising the client on whether or not to answer questions put to them in the interview, and that's a separate class altogether. Advise the client how the interview will be conducted by the police, and advising the client what role the solicitor will play in the interview. Question, what can and cannot the defence solicitor do in the police interview? The defence solicitor can request police disclosure, e.g. further evidence not previously disclosed, challenge any improper police questioning or conduct, advise the client not to answer police questions. The defence solicitor cannot answer questions on behalf of their client, nor can they provide written replies for their client to quote from. Question, where should the defence solicitor sit in the police interview room? Well, you need to know there is no police power to dictate where the defence solicitor should sit. Sometimes the police will try to distance the client from the solicitor by asking the defence solicitor to sit behind them to make them feel isolated, alone and vulnerable in the police interview room. It is important for the defence solicitor to sit beside their client during the interview, which allows for proper eye contact with the client and that they feel psychologically at least supported. We now move on to a series of really important questions. Question, when should the defence solicitor intervene during the police interview? Police questioning, the questioning techniques employed by the police is inappropriate or improper. Police conduct issues, the police are behaving in an inappropriate manner. Or client, the client would benefit from further private legal advice. Let's look at a couple of these in turn. When should a defence solicitor intervene in the police interview? Let's look at police questioning. Inappropriate police questioning includes irrelevant questions, making a statement, asserting facts, misrepresenting the law, misrepresenting the strengths of the case against the client, upgrading a response from the client, putting words in the client's mouth, making assumptions, hypothetical and speculative questions. When should a defence solicitor intervene in the police interview? Police conduct. The police are acting in an oppressive manner, including torture, inhuman or degrading treatment, and the use of threat or violence, whether or not amounting to torture. And we're going to look at Section 76 of PACE later. The police give legal advice on the consequences of silence. The police offer inducements. There is a reference to a client's previous convictions. New information is introduced that was not disclosed earlier. The police provide an inaccurate summary of the interview by the interviewing officer, and there's already sufficient evidence to charge. Question, when should a defence solicitor intervene in a police interview? Looking at client issues, the solicitor is concerned about the client's behaviour or conduct, and the client is making comments that may have adverse consequences later in the case. Question, can the defence solicitor be removed from a police interview room? Another really important set of questions. Yes, only if their conduct is such that the interviewer is unable properly to put questions to the suspect, and that's in Code C. Paragraph 6D of the notes of the guidance to Code C provide that paragraph 6.9 will apply only if the solicitor's approach or conduct prevents or unreasonably obstructs proper questions being put to the suspect or the suspect's response being recorded. And there are examples of unacceptable conduct by a defence solicitor, and they include answering questions on the suspect's behalf or providing written replies. Pay careful note to this question. What steps must be taken to remove a solicitor from the police interview? If the officer conducting the interview considers that the conduct of the solicitor is preventing them from properly putting questions to the suspect, the interview Interviewer must stop the interview, consult an officer of at least the rank of superintendent, speak to the solicitor, and decide if the interview should continue in the presence of the solicitor or not. If it is decided that the solicitor should be excluded from the interview, the suspect must be given the opportunity to consult another solicitor before the interview continues, and that other solicitor must be given an opportunity to be present at the interview. Question: when can a solicitor not be removed from the police interview? A solicitor should not be removed from the interview for telling their client not to answer questions, or intervening when they consider the police are asking questions in an inappropriate manner, or deciding where they, the defence solicitor, wish to sit in the police interview. Now, going back to those test your knowledge questions, look at test your knowledge 1, pause the video, read the question, note the answers in red, and look at why option A is wrong. Look at test your knowledge 2, pause the video, read the question, look at why the answer is E. Test your knowledge 3, pause the video, read the question, and check the answer. Again, test your knowledge 4, pause the video, read the question, and note why the answer is question A. Finally, remember, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Understand the legal concept, revise from a good SQE book, attend and participate in class, prepare Q&A flashcards, practice as many SBAQs as possible. Don't forget to subscribe to Community Legal Education on YouTube and put your notification on so you don't miss out on more SQE Prep videos. Hope you found the class useful. See you in the next class, and thank you for watching.